live.
Hello and welcome to the first webinar in our data series. So before we start the webinar, we have a few housekeeping points. There will be an opportunity to ask questions via the chat function throughout the presentation, to post any questions that you may have, and we'll look to address these at the end of the presentation where possible. As I mentioned, this is the first webinar in our series focusing on data, intellectual property security and consequences of data breaches, part of a wider series of webinars from the Commercial Dispute Resolution team. This webinar will cover the ownership of data, and the other webinars in the series will focus on the law of confidence and cyber risk and the consequences of data breaches. Your speakers today are John Mackenzie and me, Gordon McTavish. John leads our commercial and international disputes team and regularly advises clients about data, intellectual property, cybersecurity, the consequences of data breach, and the surrounding regulatory framework. Tricky questions can be how to identify and protect confidential information, what can be done when it's abused, what action can be taken following a data breach, and general preventative measures to take to avoid a breach. I work in the media and technology team and advise clients on intellectual property, including its creation, protection and exploitation, information management, including data protection and freedom of information, information technology and all aspects of commercial contracts. So, why is the ownership of data important? It has been said that the world's most valuable resource is no longer oil, but data. An example of this can be seen in the valuation that has been placed upon the data held by the National Health Service of almost £10 billion per year. Although the oil metaphor is frequently invoked when discussing data, there is an important distinction between data and oil. Data is not a finite resource. The same data can be reused multiple times in multiple different ways. So whilst thinking of data as a resource like oil helps to contextualise its value as a commodity, it misses a key point about how data is generated. The mining metaphor rests on the premise that data lies within individuals, waiting to be extracted by a company or government. However, as the Pulitzer Prize-nominated author Nicholas Carr recognises, I actively produce data through the actions I take over the course of a day. When I drive or walk from one place to another, I produce locational data. When I buy something, I produce purchase data. When I text with someone, I produce affiliation data. When I read or watch something online, I produce preference data. When I upload a photo, I produce not only behavioural data, but data that is itself a product. Therefore, says Carr, I am much more like a data factory than a data mine, and in turn this makes platform providers such as Amazon, Facebook and Google more like factory owners and managers than the owner of oil wells. There's no doubt that we produce vast amounts of data. The market for data and the potential commercial applications are also rapidly growing. However, the question from a legal perspective is who, if anyone, owns the data that all of us produce, and how do you ensure compliance with data management requirements? So the format of this webinar is shown on the screen. We'll start by briefly discussing the traditional legal understanding of ownership of property and the rights which flow from this. Data is intangible, and we will consider if it is possible to assert a right of ownership over data at all. We will then consider in more detail what data is and the different types of data that can be generated before looking at the means the law provides to protect and control data. In particular, we'll consider how the law of intellectual property and the law of confidential information interact with data. We'll then move on to consider what impact GDPR has on the control and management of personal data, Whilst GDPR gives individuals greater rights over their data and imposes obligations upon controllers and processors of data, it does not regulate the ownership of data. And finally, we will consider the use of emerging technologies such as blockchain and smart contracts, which rely upon and use data for commercial purposes. We'll look at the issue of compliance with GDPR and consider who, if anyone, owns the data used by them.
Now, everyone knows that property differentiates between things that are mine and things that are not mine. That was said in First Day Heavy Transport and Adkins. And continuing with our factory metaphor, you might reasonably expect that the data you produce is your property, and therefore, by extension, you own it. However, as we will see, this expectation would be misplaced. In Scots law, ownership is seen as an absolute right. An individual who has the right of ownership over an item of property has the fullest rights in and to the thing itself. That includes the right to use it and the power of disposal. Unless this right of ownership has been limited by contract, such as renting the item to another, or by law, for example, the sale and resale of firearms is regulated, the owner's rights are virtually unlimited. Therefore, the rights associated with ownership provide a powerful basis of control and management of possessions. However, the traditional approach of the law of property is that it is applicable to tangible goods, such as, for example, a laptop, and intangible goods, such as shares in a company, but not applicable to intangible digital data. In England, the position is similar, although there are concepts such as beneficial ownership, and the position in relation to information is broadly the same. For example, in England and Wales, the courts have decided that the contents of a university exam paper did not fall within the definition of intangible property in Section 4.1 of the Theft Act of 1968, and so this data was not capable of being stolen. As recently as 2013, in the First Day Heavy Transport case, the Court of Appeal decided not to enter into a jurisprudential debate about the legal characteristics of property or whether the content of an email was information, deciding the case on a different legal basis. The court went on to say that although there was a powerful case for recognizing that the essential elements of possession could be exercised over digitized materials, that would involve a significant departure from the existing law and might have to wait for the intervention of Parliament. This was said in the Your Response case. Although the European Commission has been considering the ownership of data for several years, at present there isn't any legislation from the European Union regulating the ownership of data. Therefore, data falls through the gaps in our legal framework regulating the ownership of property, and it's not correct in law to say that you own your data. However, that does not mean that you are powerless to prevent misuse of your data or powerless over it. While it's not correct to say that you own the data that you produce, you can, for example, protect computer software, and the law grants protection to users so that they can retain control over their data. We'll go on to discuss in more detail the means by which data can be controlled and managed. The distinction between ownership and control is a subtle one. Some people may see little difference between being able to manage their data and owning it. However, the point is more than mere semantics. Legal categorization of data as property would automatically define an owner's privileges and rights. It would also mean that you would enjoy the same enforceable remedies as any other owner of property. Instead, businesses and individuals must rely on a complex web of interwoven legal and non-legal means to try and manage and control their data. And unless otherwise indicated, the following discussion applies to both Scotland and England and Wales because the law is similar in both jurisdictions and the courts take a similar approach to the question of possession or property rights in data. But before you can own something, you have to know what that something is.
So, how do you define data? One of the first challenges when considering potential rights over data or how to exercise control over it is understanding and defining what will be controlled. The European Commission currently favours the definition that data is a reinterpretable representation of information in a formalised manner, suitable for communication, interpretation or processing. This seems to be an attempt to catch all forms of data, that produced by humans as well as that generated by digital means. The difficulty with defining data becomes apparent when considering different subsets of data, which can include data that are representative in nature, data that are implied, and data that are derived. So to give these some further explanation, representative data are things like age, sex, height, race. These are usually volunteered. Implied data are those that draw conclusions from something, for example, drawing an inference from previous online activity to reach a conclusion about a person's interests, such as the suggested purchases on Amazon or recommended artists in Spotify. Derived data is data that is produced from other sources. For example, if an analysis of data produces aggregated statistics. Therefore, different individuals may assert claims of control or ownership over data at different stages. For example, if I undertake a journey by car, I'll produce behavioural data. Sensors in the car may pick up this behavioural data based upon my braking or my steering. It's not immediately clear who owns this data. Will it be the car manufacturer? Will it be the car owner, if, for example, I'm driving a rental car? Will it be the cloud provider? Or will it be me as the driver? It's also clear that different parties may have differing interests in controlling the use of the same data. Therefore, because individuals and companies cannot own data, they must rely on conventional legal remedies to attempt to control their data.
And that takes us to intellectual property. Now, sometimes the possessor of data can try and rely upon a more familiar protection mechanism, namely copyright law. Where copyright arises, the author of the work receives automatic protection without the need for registration. If copyright exists, then the owner can control how their work is used. However, data is excluded from copyright protection on the basis that copyright protects the original expression of an idea, but not the idea itself. In the EU, another possible means of protection comes from the EU's legal regime for databases. As we shall see, however, the actual data in the database is not automatically protected, and nor does the directive grant a right of ownership. Even so, copyright might afford some protection and control over the management of a collection of data, if it can be said that the content has been arranged in such a way that it is deemed to be an original arrangement of the data by the author. The EU's database directive also allows for the protection of a database provided that a substantial amount of time and money has been invested in the structure of the data. But, to be clear, neither of these protects the data itself or grants a right of ownership over the data. They protect the structure, expression, or arrangement of that data. Interestingly, the work does not need to be authored by a human for copyright to exist. This will become particularly relevant to the question of creations produced by artificial intelligence applications. The position is less clear with patents. For example, a group of academics in the UK is currently attempting to have inventions generated by an AI patented. Their application has been received by the UK IPO and is being considered. The first person to patent an invention becomes the default owner of that invention. What is not clear is whether an AI application can be an owner or whether the owner of the AI application can own the patent on its behalf. Fortunately, in respect of copyright in the UK, Section 9(3) of the Copyright Designs and Patents Act 1988 provides that in the case of a literary, dramatic, musical or artistic work that is computer generated, the author shall be taken to be the person by whom the arrangements necessary for the creation of the work are undertaken. Therefore, works created by artificial intelligence applications are capable of attracting copyright protection in the United Kingdom. The data in a database can also be protected in certain circumstances. In the well-known case of British Horse Racing Board, the European Court of Justice was asked by an English court to provide a ruling on the EU Database Directive. The court said that in order to obtain protection, there must be substantial investment in the database itself. In particular, the court said that resources used in creating a database, that is, the data, cannot be taken into account in order to assess whether there was substantial investment. What this means is that the arrangement of the database must constitute the author's original creative work, but that the data is not relevant when assessing the substantial investment. Just because your database is big does not mean that there is the necessary substantial investment. As we've said, copyright law protects the original expression of an idea. It's traditionally been understood that it is not possible to get copyright protection over facts. By way of example, an author may take facts and write a book about an historical event. The original way of expressing those facts, namely the content of the book, is protected by copyright. However, this does not stop another person from taking the same facts and writing a book on the same historical event, provided the content is not copied. On the other hand, a recent judgment from Canada suggests that the courts may be persuaded to make a distinction between facts in the public domain and copyrightable data. Amongst other things which are not relevant to this webinar, the Geophysical Service Inc. and Encana Corp. Case involved the claim of copyright in seismic data about the ocean floor. The collection of the data involved skill, time, and resources. The judge divided the data into two categories: field data and process data. The field data was the raw data collected using geophysical's tools and technology. The process data was defined as any product derived, generated, or created from the data, including, but not limited to, any and all processed and reprocessed data, interpretations, maps, or analyses, regardless of the form or medium on which it was displayed or stored. The judge decided that the field data was a compilation and that the seismic data was either a compilation or artistic work, depending on their representation. The judge said that both categories were original and that although technology was heavily involved in the collection and generation of the data, there was enough human authorship to give rise to copyright. The data was said to be an expression of geophysical's views of what the image of the subsurface of the surveyed areas represents. The non-copyrightable facts were the features of the sub-ocean itself. The judgment was upheld on appeal, and leave to appeal to the Supreme Court was refused in 2017. Now, taking a deep breath, another means by which an individual can exercise control over their personal data is under the European Union's General Data Protection Regulation, or GDPR.
Data protection legislation is nothing new. The Data Protection Act 1998 was introduced by the UK government following a previous EU directive on data protection. However, there has been and continues to be fast-paced change in this area, and there's an ever-increasing market for data as a commodity. This has caused some consumer concern and prompted a stronger regulatory response. So the introduction by the European Union of GDPR on 25th of May 2018 will not have escaped anyone's attention. The UK put this onto a domestic legal footing with the passing of the Data Protection Act 2018. So whilst GDPR was not the first law concerning data protection, it has garnered a lot of attention by members of the public because consumers are taking far more interest in what happens to their data than before. It is also far more comprehensive in scope than previous data protection laws. Whilst GDPR imposes stringent obligations on controllers and processors of personal data, a detailed analysis of GDPR is beyond the scope of today's webinar. Accordingly, we will only focus on the extent to which GDPR regulates control over personal data. It has also been widely reported that sanctions for failure to comply with the new legislation are far more severe, and the consequences of a data breach will be discussed in more detail in our third and final webinar in this series. So GDPR does not regulate the ownership of data. Instead, it allows individuals to take action to find out how and why their data is processed and managed. It also allows regulators to police the management of data and enforce compliance with data protection laws. The point of introducing the updated and more comprehensive legislation is to ensure that consumers' data is protected, used in a manner that they would expect, and that they retain certain rights over their own data. The Data Protection Act 2018 will remain in force following Brexit. The GDPR gives individuals greater control over their data, for example, the right to access their data through Article 15, the right to erasure, more commonly known as the right to be forgotten, through Article 17, and the right to rectification or correction through Article 16. Albeit in the recent case of Google Inc., the Court of Justice of the European Union has clarified that the operator of a search engine is only required to enforce the right to be forgotten within the territory of the European Union member states. Although it has been said that these rights are akin to quasi-property rights, it is not clear that individuals enjoy the same rights as that of an owner. So, for example, there are exceptions to the right of access, and the right to be forgotten can only be exercised in certain circumstances. Therefore, it cannot be said that the GDPR gives individuals the same rights of ownership as property law gives individuals over corporeal, tangible property. Neither can it be said that data controllers own the data which they control. The terms used in GDPR are data processors and data controllers. Controllers determine the purpose and the means of processing personal data, and processors are responsible for processing personal data on behalf of a controller. Accordingly, they may possess or manage the personal data, and as long as they meet the requirements under GDPR, they are permitted to put the data to use for commercial benefit. However, it is not true to say that they own it in the same way that they own other items of property, because they do not enjoy the same exclusive rights of ownership. What data controllers can do, though, is to restrict the access to data or exploit the data for commercial gain. Therefore, although they may not own the data, the controller can put it to use in the same way that an owner can put to use their personal property.
Now, another means of protecting data is to rely upon the law of confidence. We'll be dealing with the law of confidence in detail in the second webinar in this series. But in brief, the law of confidence is an additional layer of protection for information that might be covered by intellectual property rights like copyright, patents, and so on, as well as information that is not. If the information meets the legal test for confidentiality, then the recipient of the information is not allowed to use the information to the prejudice of the giver of the information without their consent. However, it is important to stress that this does not give a right of ownership of the information or the data. It merely provides a means of controlling the dissemination of the data, and there are consequences for a breach of that confidence. It's also important to have in mind that the value of confidential information often rests in its confidentiality rather than the actual information itself. So once confidentiality is lost, the value falls. For example, the best example is that of a trade secret entering the public domain. As we've previously mentioned, whilst the law of confidential information does not provide the possessors of information with any ownership rights, it can be a powerful tool for the control of the information. For example, by entering into confidentiality agreements prior to releasing data, you can protect yourselves from the consequences of any breach and limit who has access to that data. Also, the breadth of what can be protected is often far greater than that which can be protected using intellectual property law. Finally, provided you can maintain confidentiality, in contrast to intellectual property rights, there is no limit to the time that the information is protected.
So now moving briefly on to touching on blockchain. It's likely that you will have heard of blockchain, but you may not be clear on what it is or its relevance to the ownership of data. The first thing to clarify is that blockchain is not a cryptocurrency. It is not Bitcoin. Bitcoin is merely the first mainstream manifestation of its potential. IBM's Blockchain for Dummies defines blockchain as a shared immutable ledger that facilitates the process of recording transactions and tracking assets in a business network. An asset can be tangible or intangible. As each transaction occurs, it is put into a block. Each block is connected to the one before and after it, and transactions are then blocked together, creating an immutable chain, a blockchain. We are beginning to see examples of blockchain technology being used in real-world transactions and in so-called smart contracts. So, for example, you may have heard of, in November 2018, the US Centers for Disease Control and Prevention advised that romaine lettuce was unsafe to eat in any form in the United States following an E. coli outbreak. Part of the issue was that even if the source of the outbreak was identified, it would be impossible to tell which particular containers at supermarkets originated from the farm where the outbreak began. It has been reported that the supplier is to introduce blockchain technology to track each individual shipment at all stages of the transport of the goods, so that if an outbreak occurs at a farm, they know which shipments to destroy and which are safe to eat. Another example is AXA Insurance launching Fizzy as a means of obtaining flight delay insurance. Payment is automatic following a delay or a cancellation without the need to submit a claim, and this system is built upon blockchain technology. So it's clear that blockchain is one of the biggest potential disruptors to conventional data storage. However, blockchain's relationship with personal data and the control of personal data is a tense one. It is not clear how the concept of the decentralized immutable ledger, which is a key tenet of blockchain technology, is compatible with the concepts ingrained within GDPR. For those of you considering becoming involved with or already dealing in products based on blockchain or incorporating smart contracts into your business, there are some matters that you should be considering. So firstly, for example, in respect of any personal data entered into the blocks in the chain, who is the data controller for the purposes of GDPR? Second, how does the permanent immutable concept ingrained in a blockchain comply with the right of erasure or the right to be forgotten under GDPR? Finally, if you are entering data into one block in the chain, can you exercise control over the blockchain, only your block, or none at all? The answers to these questions may vary depending upon the particular blockchain, but it is important that you consider them before capturing and storing any personal data. It is therefore advisable that before entering into a smart contract using blockchain technology, that you confirm whether the blockchain is private or public, that you clarify who the data controller is, that you clarify what type of information is being included in the blockchain. So, for example, it may be that the particular public blockchain is compatible with GDPR because no personal data has been held on it or no personal data has been made public. But for relatively obvious reasons, it's not clear to us that personal data on an immutable ledger is compatible with the right of erasure. It may be possible to anonymize the personal data so that it is de-identified, but the compatibility of this with the GDPR is untested before the ICO and the courts, and so adopting this process carries a degree of risk. It is also not clear that in a shared ledger system, the data is capable of being owned. Copyright may assist by providing protection of the expression of the data in your own block, or if the blockchain is private, you may be able to exercise some control over the data using the law of confidential information in respect of the particular block which you have created in the overall chain. However, in a public blockchain, the law of confidence will be of little assistance. At the beginning of the webinar, we mentioned decisions of the English courts about the proprietary status of data. You will remember that we discussed that the courts have struggled with the concept of ownership of data and digital assets. The Court of Appeal has said that the common law draws a sharp distinction between tangible and intangible property, and that the concept of possession has no meaning in relation to intangible property. So what does this mean and why does it matter? So according to an 18th century decision of the Court of Appeal, colonial bank against Winnie, all personal things are either in possession or in action. What this means is that a personal thing must be either something which personal possession can be taken, or something which can only be claimed or enforced by action, as opposed to taking physical possession. Digital assets such as Bitcoin do not fall neatly into either category, because physical possession cannot be taken over them, and because Bitcoin is a blockchain technology, it is decentralized, so it is not a claim against any person that can be enforced by an action. So this begs the question, is blockchain a third category of personal property in English law? The English High Court has recently granted an asset preservation order over Bitcoin, finding that there was a serious issue to be tried in the case regarding a proprietary claim. That's the case of Robertson. This follows a 2019 decision of the Singapore International Commercial Court, which agreed that though the matter was not disputed, that Bitcoin was personal property that could be the subject of a trust. So whilst this is not conclusive because the claim could be ultimately unsuccessful, it is clear that the law is undergoing considerable development and that the question of ownership of digital assets is unclear.
So to summarise today's webinar, at the moment there's no specific proprietary right of ownership recognised in data that would traditionally be understood. The law gives the users of data various means to protect the data. Intellectual property law can be utilised to protect data provided that certain requirements are met. For copyright to apply, the arrangement of the data must be suitably original, but does not have to be produced by a human. For database protection, a substantial investment must have been made in the arrangement of the database. We've discussed how the law of copyright appears capable of development to accommodate new means of creating content whilst utilising data collection and generation methods, and it remains to be seen whether such an argument would be accepted by the courts in the UK following the Canadian case. With confidential information, this can be used to great effect to protect a broad range of information and to limit its disclosure. The law allows for almost indefinite protection, provided that confidentiality can be maintained, and of course that the information is in fact confidential. If confidentiality is breached, then the offending party can be sued for breach of confidence. We examined the quasi-property rights which have emerged under the GDPR. Whilst the GDPR undoubtedly gives individuals greater control over, access to, and influence over how their personal data is collected and stored, it does not give them an absolute right of ownership over their data. However, nor does the GDPR give the collector of the data the right of ownership. But the GDPR does permit the controller to use the personal data for commercial purposes, provided that certain requirements are met. Now, that concludes today's webinar. Thank you very much for your attention. We have allowed some time for questions, and as mentioned at the beginning, this can be done by putting questions into the attendee question box. I'm just looking at the screen just now. I see there are no questions, but if you would like to follow up with questions after the webinar, please do not hesitate to contact us. We'd be happy to help. And if you'd like to find out about our webinars to follow, or to catch up on other webinar series that we've done, details are on our website. So that brings us to the end, and I'll close the webinar. Thank you very much.